There you go. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, and welcome to today's remote sitting of the Appeals Court. Let me begin by introducing the panel to you. I am joined today by Justice James Milkey and Justice Joseph Diffkoff. Before we begin, just a couple of reminders. Each side has 15 minutes to present their argument, which I'm sure you both know, and you probably also know that there is no rebuttal in the Appeals Court. Also, to let you know that we reviewed the entire record, and so it behooves you to get right to your arguments, and you don't really have to worry about the background unless it pertains to what you want to tell us this morning. Lastly, we've had great success in this format, but we do from time to time experience some technical difficulties. And if we do, we ask your patience with us, and I can assure you that we will be patient with you as well. So with that said, I'm going to call the first case, which is Commonwealth versus Matthew Marcotte, 2020-0357. And Attorney Kim, you're first, correct?
It's actually Nordby.
Nordby, excuse me, Diane. Okay, thank you. Excuse me, I apologize. Attorney Nordby.
Yes, thank you. Good morning, Your Honors. May it please the court, I represent appellant Matthew Marcotte, and I'm attorney Diane Nordby. Every defendant deserves a fair trial, and Mr. Marcotte was deprived of that for 5 reasons that we have established in our brief. First, there was the Commonwealth did not remedy, the court did not remedy Commonwealth's improper and inflammatory comments during closing. Second, the defendant was effectively prevented from testifying because the Commonwealth was allowed to impeach with evidence of prior bad acts. Third, the evidence presented at trial was legally insufficient to establish guilt beyond a reasonable doubt. 4, Commonwealth presented its case through leading questions, which resulted in a substantial miscarriage of justice. And 5, Mr. Marcotte was materially prejudiced by ineffective assistance of his counsel. Now, to go into each of those briefly, I know that your honors have read the record, but the first comment that is at issue was during closing arguments. Prosecutor made comments that spoke to Mr. Marcotte's guilt and his character that we believe were inflammatory to the point where it was highly prejudicial. The prosecution said that he turned off his ignition and dropped his keys to the ground. But instead of just describing that act alone, as they should have, which was on the record, they went a step further. There was no reasonable inference here as to speaking to his guilt. So the comment that was problematic was the prosecutor argued that the defendant even stuck his hands on the ignition, turned it off, dropped the keys to the floor as if to say, ha ha, I'm going to shut off the vehicle and you can't find me guilty of, or you can't arrest me for an OUI. Now, we believe, now I think the prosecution could have gone as far as he stuck his hands on the ignition, turned it off, and dropped the keys to the floor. But to go that extra step further to say, ha ha, I'm going to shut the vehicle off, you can't find me guilty, there was no inference of that. Mr. Marcotte did not testify. The officers testified that, he didn't look like he was, mocking them or ridiculing them.
Counsel, do you feel it was proper for defense counsel to argue? He said, you're ruining my life. I was parked. I wasn't doing anything. I wasn't driving. I wasn't going anywhere.
Do I feel that? Could you repeat that question? I'm sorry.
So in closing argument, defense counsel said, he said, you're ruining my life. I was parked. I wasn't doing anything. I wasn't driving. I wasn't going anywhere. Was that improper?
I believe so, yes, Your Honor. But I think the problem is the prosecution here was characterizing him as already guilty. They were speaking towards his consciousness of his guilt. They were saying he already thought he was guilty, so he was trying to tell them that no, he wasn't guilty. With that comment, Your Honor, he was specifically saying, the defense counsel was saying, no, I'm not guilty. I didn't do anything. But here they were trying to characterize him as someone who was already guilty. If Your Honors we have a case in the Commonwealth versus Kozak, 399 Mass 514, where they specifically said, the defendant could have described the defendant's actions, but when you went a step further to say the defendant was trying to escape and was trying to avoid being guilty, that spoke to the consciousness of guilt, and that's what.
Well, counsel, let me ask you a question in terms of putting this in perspective. Let's say we agree with you that it was a sarcastic comment. Hypothetically, we agree with you, the sarcastic comment. That could have been, as the Commonwealth often says, better left unsaid. Where's the real prejudice to your client here, given the evidence and given the way the case was tried?
That's a great question, Your Honor. So at the end of the day, there was no curative instruction. There was no specific curative instruction from the trial court. If you look at another case.
But of course, the jury was instructed that closing arguments are not evidence. Right.
Yes, correct, Your Honor. But at the end of the day, we think this comment was way too prejudicial. This comment made our client sound like a deviant, like he was trying to ridicule and outsmart the police, and that he was already guilty. And we think this comment was just so far beyond the pale that it did prejudice him, and it did require a specific curative instruction saying that comment where he seemed like he was guilty, where he was making fun of the police, where he was outsmarting them, that should be ignored. We think a specific curative instruction would have been necessary, especially considering that at the end of the day, there was not a lot of other evidence to go on. Would you remind me whether or not counsel asked for a curative instruction here? He did not, Your Honor.
I thought, okay.
So at the end of the day, we think this comment was extremely prejudicial. There was, especially since there was not a lot of other evidence to go on. And, the Commonwealth will have you think, oh, this was just, we were just trying to explain the operation of the vehicle. His mindset, his state of mind was not at issue here for the operation of the vehicle. When they speculated as to what he was thinking, they played on the jury's motions that this is someone who was trying to outsmart the police. And of course, then you want to punish someone like that, and they already characterized him as guilty. So at the end of the day, we believe that comment was extremely prejudicial and resulted in a substantial miscarriage of justice. To go on to the second point, Your Honors, we believe that our client was effectively prevented from testifying because the prosecution was allowed to impeach him as to his prior alcohol use, and that effectively.
Before you get deep into that, the U.S. Supreme Court, if the judge finds you can have prior convictions, says you have to testify or you can't object to the prior convictions. We've rejected that, but I couldn't find anything going beyond prior convictions. I couldn't find anything applying that to a motion in limine about, say, just general prior alcohol use or drug use. Have you found anything applying that doctrine beyond the context of prior convictions?
Not just general alcohol use, no, Your Honor. But
anything that isn't prior convictions, I couldn't find that. But
I have not found anything either, Your Honor. But I think what is at issue here was not the prior conviction. The prior conviction, the prosecution did say we weren't going to bring up the prior conviction here.
Okay, counsel, specifically, what is your understanding of what the judge was allowing the Commonwealth to inquire about had your client testified? Because I for one, am not sure of that.
Great question, Your Honor. The judge at first said that you can ask about alcohol use and drug use, and then later changed their mind and said you can only ask about alcohol use. You cannot talk about prior convictions.
No, but I understand that. But within that, there's a huge range. Have you ever touched alcohol is a question that fits there. And have you ever driven drunk is another question, but those are very different.
Correct. And I think that partially goes to the ineffective assistance of counsel argument, where that should have been fleshed out, where prior counsel should have been able to establish, well, what are the bounds? What exactly is prior alcohol use? Did you ever have one drink in your life? Have you ever been drunk? Have you ever driven drunk? And I think what the problem here goes to his continuance without a finding that he had in 2015. He had a quaff in 2015 for an OUI. And because that's not a conviction, that was fair game, because all the Commonwealth said was, we're not going to talk about prior convictions. The quaff is not a conviction. And so
you actually think that the judge would have permitted the defendant to be impeached because he entered a quaff on an OUI, the exact same offense?
Well, that's the problem. They did not establish whether or not that would be allowed. They said, you know, you can ask about prior alcohol use. And they only said no convictions were allowed. That was all that was established. No convictions, no prior alcohol use, yes. And so a quaff isn't a conviction, so it was fair game.
Doesn't that take a fair dose of speculation to argue that that would have been admitted?
But that was the decision that the defendant made. Like, I can't talk about this quaff. The quaff isn't a conviction, so I can't talk about this. And it's
How do we know
similar.
the defendant made that decision? How do we know the defendant thought that a prior quaff would come in, and that's why he didn't testify?
Because it's not on the record, but I've had conversations with the
Well,
I know.
Isn't that exactly why we need a new trial motion?
Exactly. I agree. We do need a new trial motion so that we could sort all that out. But I think
one hasn't been filed.
Excuse me?
Have you filed a new trial motion?
They did file a new trial motion, but it was denied. The new trial motion did not speak to this specific issue, though I think it should have. Again, that goes to my issue number 5, ineffective assistance of counsel. We do think if my client would have been able to testify, there would have been many. So prosecution, the Commonwealth says that, you know, anything that Mr. Marcotte could have testified to came out anyway, but at the end of the day, we don't think so. There was other things that were not on the record that only Mr. Marcotte could have testified to. For example, it was daylight savings weekend. We had sprung forward, and we all know what it's like to lose an hour of sleep that weekend. And he was working overtime that full weekend. He was cold. There was snow on the ground. He had no heat at home, which is why he was sitting in the car with the heat on. He had just broken up with his fiance, and the fiance, so he had nowhere to go. And he could have testified that fiance was actually friends with the cops who arrested him. So there are all of these things that should have been highlighted that he wasn't able to testify to because he was afraid of being asked about the quaff. I only have 4 minutes, so I'm going to skip ahead to, I'm going to speak briefly about issue number 3. For issue number 3, I just want to point out that the Commonwealth brings up a case, Commonwealth versus Gallagher, where they, as evidence of, you know, the lady parked crookedly for an OUI, and, you know, she failed her field sobriety test. There was no breathalyzer, and therefore, you know, our cases are similar, but I think our cases are very distinct because in Commonwealth versus Gallagher, they talk about how, you know, they look for the completion of the 9-step test. And this lady, again, Miss Gallagher, was only able to do 6 steps or 7 steps. Mr. Marcotte, he actually did 10 steps that the officers testified to. So he actually completed the test in one direction, and then he just walked back regularly because, you know, he forgot. But they didn't say, okay, walk back and do another 9 steps. But my point is, he was able to do 10 steps, which
testimony was that he didn't connect feet, his heel to toe. He stepped off the line, used his arms to balance, and then walked back completely normally.
There was no line, though, Your Honor. They said, imagine a line. Miss Gallagher had a line. And Miss Gallagher, at the end of the day, she was in a brightly lit parking lot with an actual line on the ground. And they watched her park the car. It was at an OUI stop point, and so they instructed her to drive and park, and they saw her parking crookedly. No, there was no eyewitnesses here. The officers did not see my client parking at all. He was already parked by the time they got there. But I also want to skip to the last point, ineffective assistance of counsel. At the end of the day, there were a cascade of errors that we think add up to ineffective assistance of counsel. We spent a lot of time highlighting those in our brief. But at the end of the day, I want to talk a bit more about the failure to request the turret tape and to failure to do a motion to suppress under Aguilar-Spinelli. At the end of the day, under Aguilar-Spinelli, it's
either of those in your initial brief or just in the reply brief?
We said in our initial brief that there was a series of errors, and there were 2 or more errors. And so at the end of the day, we think that we just, we listed more errors, and one of them, and all of these errors that we listed are in the record. And on top of that, we did list in our initial brief a statute that allows you to file a motion to suppress on for the civil issues ahead of time. And we think that
Counsel did file a motion to suppress in this case. You attached in your reply brief.
correct, he did so, but we think
What should he have done different?
he should have written the right date and time and the right client, the right location of the arrest.
Okay, is that it? I mean, so you have to convince us that the judge denied it because the wrong date was written there. How do we know that? We don't have the transcript or the rulings.
That's correct. So we think a failure to get the transcript was another thing. But we also think that.
What do you mean his failure to get transcript? You're the appellate lawyer. You didn't get the transcript to us.
Well, I meant that he should have gotten the transcript, so that that was another part that was under argument number 3, where if he had gotten the transcript, he would have been able to impeach the witnesses that were on the stand.
How do we know that without seeing the transcript? For all we know, they said word for word exactly what they said at trial.
And we agree, like that is something that should have been done. But at the end of the day, we think in this motion, he should have requested the turret tape. He should have requested the recording of the call. There was an anonymous call reporting my client, allegedly reporting my client. But at the end of the day, there was no recording of the call. It wasn't a 911 call. And at the burden was on the Commonwealth to establish the veracity and the base of knowledge for those calls, but they failed to do so. They did not enter that case into evidence. There was the stop itself was not legitimate because the call itself was not legitimate because there's no way of verifying that.
Okay, your time is up. If I may indulge myself, but I have one question regarding the procedural issue, and that is you indicated that a motion for new trial had been filed. And what I presume you're referring to is just the motion for required finding of not guilty or an alternative ordering a new trial. Nothing along the lines of what you're discussing today in oral argument in terms of what should have been raised in a motion for new trials. Is that right?
In that motion for new trial, they did address the issue of legally that there was evidence. The evidence was legally insufficient to support a conviction. My issue number
Right.
3 and issue number 4, but the other 3 issues were not raised. So we do concede there is a higher bar there.
Yeah. Okay. All right. I've checked to see if Justice Milky or Justice Dickoff have any questions before we. No. Thank you very much. Thank you for your argument. Okay, Attorney Johnson.
Good morning, Your Honors. May it please the court, Kayla Johnson for the Commonwealth. I'll just briefly respond to the points that the defendant raised here on appeal in the arguments here. First, in regards to the Commonwealth statement and its closing arguments, that statement was a proper characterization of the evidence that was presented at trial. And specifically, Officer Bass testified that the defendant did turn the ignition off on the car and drop the keys to the floor of the car without Officer Bass instructing him to do so. And it was a fair argument for the Commonwealth to make that the defendant did so in order to try and avoid the consequences of the OUI, which was further supported by the testimony of the officers that the defendant did say that they were ruining his life in doing what they were in making this arrest of him.
Why go there?
The trial ADA who tried this case is no longer with the office, so I wasn't able to speak with her, but I suspect that this was just to make a comment on why the defendant made these actions and to suggest to the jury the inference that could be drawn from the defendant's behavior here. And I think it was supported by the evidence here by Officer Bass' statement as to the defendant's action. And I think the Commonwealth was free to make this argument. And in doing so, making this argument, it was also a fair response to the defendant's closing argument, where the defendant pointed to the fact that the officers did not see him driving that evening before making this arrest. And I think it was a fair response for the Commonwealth to make that it didn't matter that the defendant wasn't driving, that the fact that the vehicle was on when the police officers arrived, that was sufficient for the jury to find the defendant guilty here.
Let me just add, if I may, what the prosecutor intended, what he or she intends when they make a closing argument is not really what we look to, right? We look to what was said and whether or not it crossed the line. And ridicule and sarcasm never always presents a problem on appeal, doesn't it? So, and the issue is not really whether that prosecutor is still working in the office. I'm sure that that the rest of the prosecutors in your office will want to have guidance and know whether or not this is an appropriate comment to make or not. And you always run the risk in something like this.
No, of course, Your Honor. And I made that point just to say I wasn't able to speak with this ADA to see what her specific intention was in making this statement. But I think when you view the argument as a whole as well, it kind of goes to show that I think the main point that she was trying to make was that it didn't matter that the defendant wasn't driving the vehicle that night. And I think pointing to this evidence kind of highlights the fact that maybe this misunderstanding as to the law was something that the jury may have been thinking about. And I think that the important point here is that the Commonwealth was trying to highlight that it didn't matter that the defendant wasn't seen driving the vehicle that evening. And I think, go ahead, Your Honor.
I'm a little confused by the focus of the Commonwealth at trial on the driver wasn't operating when the car, as I understand it, was half in the parking lot and half out. Why wasn't that alone sufficient? And you didn't need to get into whether or not operation is required or what operation means.
And I think that is a fair point, Your Honor. But I think when we look back on the record, I think what we have to decide, or what this court has to decide, is whether this statement, looking at the trial as a whole, caused a problem. And I think, as I just stated, I think the statement was a fair comment on the evidence and suggested an inference to the jury. But I think even if this court was to find that this statement was an error, I think looking at the case as a whole and the trial as a whole, that the defendant certainly wasn't prejudiced by this statement. The defendant did not object to the statement at the time following closing, and the judge did instruct the jury 3 times that closing arguments are not evidence. That was before opening, prior to closing, and in the final charge. So I think even if this court was to find that the statement was an error, that it was not prejudicial in this case. And moving on to the judge's ruling that the Commonwealth would be allowed to impeach the defendant as to his prior alcohol use. I think going to Your Honor's point about kind of the scope of this questioning, the record doesn't flesh that out, but I think here it's important to note that the trial judge carefully exercised their discretion in making this determination.
What is your understanding of what the judge said was fair game?
My understanding, I mean, really, all the record reflects is that the Commonwealth would be allowed to impeach as to prior alcohol use, and I think that's verbatim what the trial judge used for language in allowing this motion, or allowing the Commonwealth to question the defendant. But as to the details of what that would entail, I don't think the record reflects that. My understanding would be that if the defendant had chosen to testify, and he perhaps testified to saying that he doesn't drink or something, perhaps the Commonwealth would then question him as to prior alcohol use at that point. But again, the record doesn't really reflect the details of what would happen there. But I think that it's again important to note that the trial judge did carefully exercise their discretion in this case, and I think that really is highlighted by the judge.
How do we know that if none of us can say what the judge intended as to the scope of the order?
Well, I think it's important to note that at first the trial judge was going to allow the Commonwealth to impeach the defendant as to his prior drug and alcohol use. So I think perhaps there was perhaps the judge was thinking that in this case, where to bring up prior drug use would be prejudicial to the defendant, but where this was a case involving alcohol use, that perhaps if the defendant was going to testify to the effect that he didn't drink, that then the Commonwealth would be permitted to question the defendant. But of course, it is the record does not indicate clearly what the scope of this questioning would be. But I don't think that prevents this this court from finding that the judge properly would have allowed the Commonwealth to do this. And I think, again, even if the determination was in error, I think the defendant has failed to show that this prejudiced him in any way. The record does not make clear whatsoever that this alone was the reason that the defendant chose not to testify in this case. There are a variety of reasons that the defendant could have chosen not to testify, and the record certainly does not indicate that this was the reason solely for him choosing not to testify. And again, all the evidence that the defendant says that he would have presented had he testified was already before the court at the time through the testimony of the officer, including that he was partially blind, that he was very tired that evening, and that there was snow on the ground. And I think the record does not indicate for certain that this determination alone was the reason that he chose not to testify.
To what extent are you saying that the issue needed to be fleshed out in a new trial motion?
I think if the defendant says now on appeal that there is more evidence that he wished he would have put before the court at the time through his testimony, I think certainly a new trial motion would be important in this case to be able to flesh out those issues. And that was not filed in this case. And as the court pointed out, the motion that was filed post-conviction was the motion for required finding, or in the alternative for a motion for new trial. But a new trial motion in the sense that we could actually flesh out these issues has not been filed. And I think that is important for this court to consider on these issues, particularly where the defendant is now on appeal claiming that there's more evidence that he wished he could have put before the trial judge. And just to briefly address the sufficiency in this case, the Commonwealth evidence was thoroughly sufficient to support a finding that the defendant was impaired on the evening that he was arrested. There's testimony that he seemed confused, he had glassy red eyes, slurred speech, smell of alcohol coming from his breath. He admitted that he was drinking that night, and he was unsteady on his feet and was unable to complete the field sobriety test. So I think the evidence in this case was thoroughly sufficient to support the trial judge's denial of the motion for required finding. And just briefly, again, to address the defendant's claims of ineffective assistance, the claim now in the defendant's reply brief that the defendant's trial attorney was ineffective for failing to request these turret tapes and the audio or the transcript from the motion to suppress was not raised in their original brief and was only raised in their reply brief. And again, I think this goes to the importance of the fact that a motion for a new trial was not filed in this case in order to flesh out any of these issues that the defendant is now raising as to ineffective assistance of counsel. And I think even looking at the merits of the claims that were actually raised in the defendant's original brief, not in the reply brief, I think that, as I stated, I think even if the defendant had objected to the Commonwealth statement in its closing, that likely would have been overruled by the trial court, where he later found that statement was a fair comment based on the evidence that was introduced. And I don't think the defendant has met his burden to prove that this motion would have been allowed, or that the objection would have been sustained at the time. And any motion to suppress the photographs, I don't think the defendant has shown that was a viable motion either. And the defendant certainly does not advance an argument as to why a motion to suppress the photographs of the bottles of alcohol would have been allowed at the time. So in conclusion, if the court doesn't have any other questions, the Commonwealth will rest on its brief.
Okay, let me check with the panel. I don't see any questions, so thank you both very much. We'll take the case under advisement and get an answer to you as soon as possible. Thank you both.
Thank you, Your Honor.
So from here, you should press more and stop YouTube.
We're live.
Thank you very much. All right, good morning, everyone. Let me begin by introducing the panel to you. I'm joined this morning by Justice James Mielke and Justice Joseph Dukoff. A couple of and my name is Ariane Buno. A couple of reminders before we begin. You can be assured that we've read the entire record, and so we're familiar with the background of your case. 15 minutes can go by quickly, so please get right to the points that you want to make during the course of your argument. Second, as you know, you each have 15 minutes and there is no rebuttal. It's not necessary to use all of your time if you don't feel you need to do so. And the last reminder is we've had great success with this platform, and we're very grateful to be able to use it so we can all stay safe and appropriately distanced. But upon occasion, we do have technical difficulties. If we do, we will be patient with you, and we hope that you'll be patient with us. So let me now call the next case, Commonwealth versus George Perrott, 2020-0108, and Attorney Madison. Please begin.
Good morning, and may it please the court. Nick Madison for George Perrott. This case is controlled in all material respects by the case of Commonwealth v. Hartfield. And when the judge in this case excluded non-cumulative relevant impeachment evidence in a probation violation hearing where the credibility of the complainant was critical in making the factual determination as to whether or not there was a violation on the basis of rape, Mr. Perrott's due process right to present a defense was violated. And that violation requires the vacation of the revocation order in this case. Now, I'm happy to begin with the mootness issue, since that issue was raised by the court. And so the rule from Commonwealth v. Malott, I believe, I'm not sure if I'm pronouncing that correctly, is that any challenge to a factual finding of violation, of a criminal violation, is mooted by a subsequent conviction or guilty plea for that crime. That rule does not apply to this case because the offense, the factual finding of violation that we are challenging here, which is a violation on the basis of rape, was not the subject of a later guilty plea or conviction. The later guilty plea was to indecent assault and battery. And so the Malott rule doesn't apply for that reason.
And what was the basis for the violation of probation? It wasn't just the rape allegation, right?
That's correct. There were 6 alleged criminal violations and a drug screen violation. What Mr. Perrott was found in violation for. And in this regard,
wouldn't we have to find that there is some chance that if the judge had only found an indecent assault and battery and all the other crimes and the drug screen, that he wouldn't have imposed the suspended sentence?
I wouldn't phrase it that way, and I'll address that point right now. I think the rule of Malott needs to be read in conjunction with the rule, a separate line of cases that includes Aquino and Arroyo, which are cited in my brief. And those cases stand for the proposition that when multiple factual violations are found and result in a revocation of probation, later finding that any one of those bases is infirm requires remand to the trial court.
Right, but in Arroyo, the court found the improper assault and battery was a substantial factor in the judge's decision. In Aquino, these subsequent crimes couldn't be properly considered. Only the technical violations were okay. Here, we've got all the crimes, and we've got the involuntary sexual assault. The only thing that's in question is penetration. So don't we have to find at least some way it was a factor?
Penetration and force would be a distinction. But I think when you read those cases, and after receiving the order of the court on Thursday, I did some research, and I came across the case of Commonwealth v. Pearson, which is an unpublished case from 2014, docket number 13P978, and the table citation is 86 Massachusetts Appeals Court 1124. And in that case, there was 2 factual violations found. One, it was a crime of possession of a dangerous weapon, and another was a non-criminal violation that was articulated as a quote-unquote testing failure. And in that case, there was a subsequent guilty plea to the crime, to the offense that was the subject, the possession of a dangerous weapon. And so the court applied these two cases, these two lines of cases, the Malott and the Arroyo Aquina cases, and said, well, any challenges to the criminal violation are mooted by the guilty plea. However, the probationer makes separate challenges to the non-criminal violation, the testing failure. And in that case, they found that the testing failure could not stand as an independent violation, and remanded to the trial court to sentence just on the criminal violation. And now that's a little bit counterintuitive, because one would imagine that from a trial court's perspective, the criminal violation would probably be doing the heavy lifting in a decision of whether or not to revoke probation. But the principle that court articulated, and I believe this is the principle of Arroyo and Aquino, is, and I believe I'm forgetting if it's in Arroyo or Aquino, it uses the language of usurpation, that the decision after a finding of violation, the decision of whether or not to revoke probation, is a discretionary one for the trial court. And when multiple violations are found, the decision of an appellate court to step in and say, here's what we think the judge would have found if faced with this different set of violations, is actually a usurpation of the trial court's discretion in the first instance, and that the appropriate.
Let me ask you this: what in your challenges to how the credibility of the complainant was handled would go to the distinction between rape and indecent assault and battery?
So I think to answer your question directly, I think there was the alleged victim did make both in her hearsay statements and at the hearing, make statements about consent that would be relevant either to rape or indecent assault and battery.
But we know it wasn't consensual because your client admitted it wasn't consensual when he
That-
said it.
That is fair.
Consent isn't the problem. So what does go that you're challenging to the distinction?
To the extent, I think there's a problem insofar as you pick what was. I don't think you can pick part of the elements from what was challenged during the probation violation hearing, and then part of what was admitted to for a separate offense later, a different offense later, and combine the two into saying that there was no challenge. Certainly at the hearing, Mr. Pratt and his counsel were faced with a specific alleged violation of rape, that they made certain decisions on what evidence to challenge. And there was a later admission to indecent assault and battery. But I don't think you can combine the two in that way. But also to the point, the judge in this case explicitly in his findings on the probation violation decision on disposition, the written findings that are in my record appendix, explicitly relied upon the seriousness of the offense. That was, you listed that as his reason for revoking the Mr. Pratt's probation in this case. And so a admission to a less serious offense certainly would illustrates the point from Aquino, I think, and Arroyo, that this is a different constellation of violations. The most serious alleged violation, was not established by the guilty plea. There'd be a less serious criminal offense that would be established by the guilty plea. But that presents a new discretionary decision to be made by the trial court in the first instance. And if there's no other questions on mootness, I'll proceed to the merits. So Commonwealth v. Hartfield, building on Commonwealth v. Kelsey before that, articulated a right to present a defense in a probation violation proceeding. And specifically, Commonwealth v. Hartfield established a presumptive right to call an alleged victim and to question the alleged victim to establish either that the violation did not occur or that the hearsay evidence proffered by the or offered by the probation department was not worthy of belief. And that is exactly what Mr. Perot sought to do here, which was
in a trial, if your client had gone to trial and the judge had applied Rule 60, guided evidence Rule 607, would that have been a due process violation?
I question, well, at trial, it would be a slightly different setup because the Commonwealth wouldn't have been able to proceed with the alleged victim's hearsay statements. That's the nub of the problem with relying on 607, is that the probation department got to admit her statements and that Mr. Perot didn't get to only got to impeach them in one limited fashion, which was by prior inconsistent statements. And to your point, if the rules, the guide to evidence applied in probation violation proceedings, this particular issue is actually pointed out by Section 806, which says that when hearsay statements are admitted, the opposing party is allowed to impeach those as if the declarant had personally appeared and testified. And so the rules themselves acknowledge this particular problem, I think, and strike the appropriate balance, which is to say that and this comes also from the case in Mahar, that a proponent of an absent witness shouldn't be put in a better position than a proponent of a live witness. So I don't know that I can answer that question as phrased because the Commonwealth wouldn't have been able to proceed for confrontation reasons on the hearsay statements. And I go through in my brief, and since I'm short on time, I won't reiterate it on why reliance on Section 607 was erroneous. I will just comment briefly on some of the bases proffered by the Commonwealth for why this information, for why this evidence should have been excluded. The Commonwealth suggests that the rape shield statute the judge decided on that. And I would respond that a close look at the record shows that the judge did not rely on the rape shield statute. It was brought up, it was discussed. The judge very explicitly made his ruling on Section 607 multiple times, repeated that 607 was the reason for his decision. And that's significant because the rape shield statute, both for the exceptions contained within the statute and the non-statutory exceptions that apply here, require a balancing test that there's no evidence that the judge ever conducted, because he wasn't, the record's clear that he wasn't excluding it on that basis. And so, and even if he were, that wouldn't encompass all of the evidence that was excluded. It wouldn't have encompassed the convictions for non-sexual conduct. Under Harris, it wouldn't have encompassed even the convictions for sexual conduct. That would be subject to a separate balancing test. And actually under Joyce, the evidence of motive to fabricate falls outside of the rape shield statute and subject to an analogous but different procedure. And the Commonwealth also relies on more or less the general discretion of a judge to order evidence, or that it was cumulative. And I would just say that the judge did not exclude this evidence as cumulative. In fact, he excluded it before the witness started even testifying. And there's some basis in the record to believe that he hadn't had an opportunity to review the grand jury minutes yet that had been admitted. And so he didn't know necessarily what the evidence was, and he couldn't have excluded, at least from the alleged victim, and he couldn't have excluded it as cumulative. And obviously, the judge's discretion to control the flow of evidence would not go so far as to allow the exclusion of evidence that it was essential to to a probationer's right to present a defense, which I would argue is the lesson from Hartfield as it applies to this case. And just to touch on harmlessness very briefly, I would just note that obviously if there was, as I think is compelled by Hartfield, a due process violation from the exclusion of this evidence, the Commonwealth bears the burden on proving harmlessness, and where the facts of Hartfield are actually very instructive here. It's a very similar case of an alleged rape and curtailing of a complainant's testimony. And because the judge had to rely, at least in part, on the complainant's testimony in establishing this violation for rape, I don't, the Commonwealth can't meet its burden to prove it.
Why did he need to rely on the complainant's testimony to find a violation of rape? The officer in the grand jury minute says he saw oral sex being given on an unconscious person.
So I see my times, if I can just respond briefly to
Please
the
answer. Mm-hmm.
So if the probation department was going down the road of inability to consent, then Mr. Perrot's what he knew or what he reasonably should have known becomes an element of the Commonwealth's case. And so all of the things that happened up to the moment that the police arrived would be relevant, and the complainant made statements as to what happened, and the defendant was entitled to rebut those. So it wasn't established just by what the officer, it had to include the hearsay statements or testimony by the alleged victim of what occurred before.
To show a lack of consent?
To show Mr. Perrot's what he should have knew, or the Mountry element of what he knew or reasonably should have known regarding the complainant's inability to consent at that time.
Okay. I see no further questions from the either panel members. So thank you very much for your argument, and we'll return now to ADA Moriarty.
Good morning, Your Honors. May it please the court, Marina Moriarty on behalf of the Commonwealth. The Commonwealth suggests that this appeal is rendered moot by the defendant's plea on the underlying offenses. Like in Malott, where the reliability of the hearsay evidence was challenged on appeal, here the nature of the defendant's appeal is essentially that the victim was unreliable and manufactured a lack of consent. This goes to the fact-finding or adjudication portion of the probation violation proceeding, and where the defendant has already agreed that her claims are true beyond a reasonable doubt to so much of the claim that alleged an indecent assault and battery, which also requires an element.
How do you allege your brother's argument that the Arroyo line of cases says that if there's a problem with any aspect of the grounds on which the judge relied, it has to go back?
I still think that the Malott line of cases would control, where that there is no error in any portion of this proceeding, where the defendant conceded that there was force and a lack of consent. The only distinction would be penetration. And so in this case, there is no procedural constitutional issue with the disposition portion of the proceeding. This court can be confident that the defendant's claims of his inability to question the victim fully on her supposed claim of recent fabrication of lack of consent is simply not an issue, and this case is moot. This case doesn't involve a constitutional defect of the sort discussed in Pena, which was an ineffective assistance of counsel issue, where the court held that a procedural aspect violated constitutional rights, and a probationer's right to present material relevant to the discretionary stage of the revocation proceeding made the appeal preserved the live issue. Here, the defendant's claim of error pertains to the judge's factual finding that he violated his probation, not some procedural error, and therefore the issue is moot. I would agree with Justice Ditkoff, that there is simply no distinction, relevant distinction in this case between the defendant's plea to indecent assault and battery and the allegation of or the probation violation that alleged rape.
Asking questions here. I'm just asking questions. You don't know what I think.
I'm sorry, Your Honor. I'm sorry. I would point out that there is a case by a different panel of this court, Raposo, which where the violation relied on a deliberately pouring scalding water on a child, and it was charged as an assault and battery on a child causing bodily injury. And then the eventual plea was simply to reckless endangerment of a child. And the original charge of assault and battery on a child causing bodily injury was null prost. And so in that case, I can see where there would be a live issue and where the appeal would not be moot. But here, where simply it's a lesser included offense, and the defendant's defense and the defendant's defense at the probation violation hearing and the defendant's claim on appeal goes to lack of consent, I would suggest that Malott controls. Even if this case were not moot, the defendant would fare no better. The judge properly precluded the defendant from impeaching the rape victim with certified convictions, where it was his choice to call her at the probation violation hearing and where his questioning was otherwise incredibly vigorous and thorough. And this court would have to find that the judge violated, abused his discretion in excluding those convictions, which I would point out only go back to, with the sex for a fee, 2 charges for sex for a fee. One was in 2008, one was in 2011. Lewd and lascivious conduct was in 2013. The 3 most recent charges, 2015 and 2 in 2018, were for trespass and simple misdemeanor drug offenses. So really the defendant's claims that this was that she recently contrived a lack of consent theory to avoid being charged herself really had to go back over 6 years in order to find some sort of sex offense on which to supposedly cross-examine this victim. Notably, defense counsel didn't pursue a line of defense on this point. He completely abandoned it without he could have asked. There's nothing that would have prevented him from asking whether she was fearful of being charged or had she considered being charged. That would have been a proper line of inquiry, which he abandoned. I think the court properly relied on the proposed Rule 607, particularly in the case of probation violation hearings, which are supposed to be streamlined and where the rules of evidence don't necessarily need to be strictly applied. Here, the defendant, consonant with due process, was able to call the victim, cross-examined her, impeached her with prior inconsistent statements, and the judge just simply exercised his discretion in deciding to exclude the prior convictions.
How do you address your brother's argument that there's no showing here that the judge relied on the rape shield statute?
I do think that it was at least raised by the Commonwealth as a reason to exclude it. I do think that the judge considered, I don't think it was an explicit balancing test, maybe that is ideal in these types of situations, but I do think that he agreed with the Commonwealth and used the word speculative to consider whether in that moment the victim was aware that she was potentially subject to arrest. I agree that his decision was more explicit on the point, but but where the Commonwealth raised the specific rape shield statute, I think this court could affirm the judge's decision on either point. I would just point out that the defendant had the opportunity to question the victim about her memory of the events that day, her dependence on heroin, her use of methadone, her use of prescription medication, her consumption of alcohol, and impeached her on several points on her grand jury, attempted to impeach her with her grand jury testimony, and impeached her with inconsistent statements that she may, or potentially inconsistent statements that she provided to the EMTs and Officer Carmichael. The detailed and intense questioning in this case clearly led the court to be aware of the potential limitations to this victim's memory, but the judge had the opportunity to observe and assess her credibility as she sat on the stand. And I would simply suggest that there was no due process violation, and in this case, the court's central concern of a reliable and accurate evaluation of whether the probationer indeed violated the conditions of his probation was served, given the lengthy hearing and numerous witnesses that all testified and documentary evidence that was presented to the court. If the court has no further questions, I'm happy to rest on my brief.
I'll check with the panel. I see no questions from either one. I don't have any questions either. Thank you both very much for your arguments. We'll take the case under advisement and again answer back to you as soon as possible. Meanwhile, stay safe and stay healthy.
Thank you, Your Honor.
Thank you, Your Honors.
We are live.
Okay, thank you very much and good morning. Welcome to today's remote sitting of the appeals court. I'm joined today by Justice James Milkey and by Justice Joseph Ditkoff. My name is Ariane Buno. I recognize both of you, so I know that you know our rules and all the procedures that apply to oral arguments. You each have 15 minutes and there's no rebuttal. Just to remind you that we have read the record and we are familiar with your arguments, so you can use your time accordingly. The last thing I want to say is that you've also both appeared in a remote platform, and so you know that upon occasion we do experience some technical difficulties. If we do so today, and we hope not, so far so good, please, we ask for your patience and we'll be patient with you as well. So with that said, let's call the case. It's John Doe number 264045 versus the Sex Offender Registry Board. And the number of the case is 2019-1726. And Attorney Campbell, you're first.
Good morning again. Once again, Your Honors, may it please the court. I'm Brandon Campbell for the petitioner John Doe. Unfortunately, I have to start my argument with correcting a misstatement in my brief. It appears at page 18, note 11. I stated that the risk percentages were not introduced in this case. That's referring to actuarial test results. Actually, at Exhibit 2, page 81, the risk results from a purported combination of the static 99R and stable 2007 actuarials equals 19.1% over 3 years. My brief should have read the risk percentages were introduced in this case, but it does not appear, at least from the decision, that the hearing examiner relied on that. So
Okay.
That said, I'd like to proceed to the first argument in my brief, and I will admit that there is a lot of overlap in these arguments. So I anticipate your questions. My first point is that the hearing examiner erred in denying Doe's motion for expert funds. So in this case, Doe received discovery, would have known that the board planned to introduce the evaluation from the treatment center that contained the results of actuarial tests. Prior counsel.
Counsel, can I just stop you there? As you concede in your brief, you had to show, or the counsel had to show to the hearing examiner that there was something specific in the fees request to him. A generic request for assistance isn't enough. How do you overcome that hurdle in this case where the arguments are somewhat general and don't appear to be specific to him?
Yes, sorry about that. Your Honor, with respect to that, I would prefer that my prior counsel had had a more specific motion for expert funds, but I think that what was included was sufficient because he was asking for an evaluation under an expert to do the static 99. He wanted to do that. This was going to be and was an issue in this case. Prior counsel was aware of it, and he asked for funds so that he could get an expert and do an evaluation under these actuaries, which the board introduced, and I submit that the hearing examiner used incorrectly under George. Even if this court should find that the motion was insufficient, I submit that it is, and all of the claims at a minimum are reviewable under the ineffective assistance of counsel claim. But my first position is that there was enough there in that motion, and so that it's not an unpreserved claim. Under the George case, which is admittedly an SDP case, but I think the reasoning applies exactly, and if not more so in the SORB context, these risk bands, I'll call them, under these actuarial tests should not be admitted. And I think it's more prejudicial in the SORB context because in the SDP context, the inquiry is largely whether or not there's a likelihood that the person will reoffend if not confined to a secure facility. Whereas in SORB cases, there's a stratum of kind of a decision that has to be made, right? Is it going to be any level? If so, is it going to be a 1? Is it going to be 2? Is it going to be 3? Is it going to be a low risk to reoffend? Is it going to be a moderate risk to reoffend? Is it going to be a high risk to reoffend? And all of these are elements of what the board must prove. And when you have these test results come in that say that that place the petitioner in a cohort with a high risk of reoffense or a moderate to high risk of reoffense, as was the case here, that was highly prejudicial.
Okay, but before we get to prejudice, you would admit, I take it, that the SDP context is different in various respects, including most basically who the fact finder is. A jury in the case of the SDP and an administrative officer in this case. Wasn't the SJC's concerns in George related to the potential effect on the lay juror as the fact finder? And is it plain those kinds of concerns would apply in the context of an administrative officer?
I see the distinction that you're making, but in this case, there's no indication from the written findings that the hearing examiner used these wristbands in the proper manner or limited them in any way. So we have no way of knowing from looking at this decision whether the hearing examiner did the right thing.
But where there's not preserved error, isn't it your burden to show that she misused these? Or have misused?
I think that the burden is to show that the first prong is what the prior attorney did unreasonable. And second part is, as you're, I think, getting to, is whether there was prejudice. And when I can't, and, you know, part of the problem with these, you know, appealing these motion for expert funds is petitioners are put in an awkward position because they don't know what they don't know, okay? Part of having an expert is being able to consult with somebody so that you can learn about what it is, what your blind spots are in your case, and understand the science behind it. So in a lot of ways, it's unfair because, you know, petitioners have to go at these with one hand tied behind their back. They have to marshal enough science to say that they've got something, and then even though they may not fully understand. So I would.
No, but counsel, getting to the specifics, isn't the administration of a static 99R test, if you will, something of a paint by numbers enterprise? To what extent, I mean, in the cases in which we've seen multiple static 99Rs performed by different experts, you know, they may be one number off at most. It's not like, you know, this test seems to require an extreme amount of expertise.
Your Honor, I think that one number off is important, and I've noticed that there, even in the George case, that the two experts that testified came out with different static 99s. There was a static 99 that came out as a 5, apparently from New Hampshire, and the static 99 by the treatment center appears to be a 6. I don't know whether that's a difference between the R and the regular test. Which is one of the reasons petitioner could have really used an expert in this case to address that.
Well, how do you address the fact that in George, even though it was preserved error, the court ultimately concluded that it didn't warrant reversal?
Well, the court in George looked at a number of different factors and concluded that that was a very minor part of the case. But, you know, this is essentially like opinion as to the ultimate issue, and to analyze to like the criminal context. This is somebody saying that the risk of reoffense is high for that cohort, and that's very close to what the hearing examiner is supposed to find. Which why isn't
that equally true in the STP context?
I think it's different because I think the analysis is whether or not the person should be confined, or they're so likely to reoffend that they should be confined, or that they can be released to the community. It's a different consideration. It's confined or released, but here there's a difficulty with the sex offender registry law and the regulations, and there is very little guidance on how to make a determination between a 1, a 2, and a 3. Okay, there is some guidance in the sex offender registry law that says that essentially what the board has codified as the first 6 factors are indicative of a high risk, and then after that there's really nothing. And as the board is fond of arguing, it is not a quantitative analysis that they go through when making a decision. It's qualitative. So a person can have all 6 high-risk factors and still be classified as a level 1. Let's say they're in a coma, or they're paralyzed, or equally, someone could have no high-risk factors and still be classified as a level 3, depending on the case. There is a tremendous amount of discretion that hearing examiners are given. That's why I think that these wristbands are so problematic in this case, because the potential for misuse is very high.
What do we do with this claim? In Doe 27914, we said that the appellate resolution of an ineffective assistance claim with a necessary factual component would be helped by input from the administrative fact finder, i.e. the hearing examiner. Don't we need to know, before we can determine whether there's prejudice, from a hearing examiner how this would have influenced them? Isn't that what the case law tells us?
So if I understand what you're saying, I have to, I'm sorry, I don't understand your question.
I guess I'm saying, why don't we need you to present this claim, this ineffectiveness claim to SORB and have a hearing examiner say, oh, that's right, if I had heard that, I definitely would have done something different, or say, no, wasn't really important to me, so it wouldn't have made any difference either way. Why don't we need that input from the examiner in this context, as DOE 27914 suggests?
Well, I'm not sure how that mechanism would work. Honestly, in generally in the field of administrative law, when there are findings that come into question, courts will remand the case and ask for additional findings. And let me point out that in the area of finality, which is the whole thing that drives the waiver doctrine, as the late Justice Gantz eloquently wrote in his dissent in DOE 209081, that's 478 Mass 454, the principles of finality just are not strong in SORB cases, because we're not dealing with a case where it's an old conviction and people are going to have to be recalled and evidence is going to get lost. What SORB focuses on is risk right now, and that's a continuing concern. And frankly, where a person such as this Doe in this case has a lifetime duty to register, that is something that's going to be potentially lasting a very long time. So the concern about remanding a case and getting like more additional details, did the hearing examiner make the decision on the proper basis? I don't think that should be as a very strong concern at all in this context.
I don't understand. What can we do besides remand it?
I'm not asking. Well, I'm asking for a remand.
Yeah.
And I think that Justice Milkey's question is like, or I'm sorry, your question was, what is my burden to demonstrate when the findings are unclear? And I think that what should happen is it should go back and they should, at a minimum, clarify the findings, if not make a new decision. And those concerns that we have about waiver are very slim. I'm not saying they're nothing, but certainly here where we're dealing with a high risk factor that will potentially influence not just the petitioner's current level, but his future classifications, then I think it should go back.
Counsel, I know your time has expired, but I have one question regarding your argument on compulsive-ness. You seem to rest the argument on a certain concurring opinion by a justice of this court. Now, I for one think that concurrence is both brilliant and correct.
As do I.
But at the moment, it is the opinion of one judge as to not where the law is, but where he thinks it should be headed. Moreover, that opinion was issued the year after the administrative ruling in this case. How could there be ineffective assistance in the failure to anticipate that concurring opinion?
Well, I think that, first of all, counsel in this case did raise the argument in Superior Court. So did at least raise it at that point, which I believe was after when the opinion raised. So because it came out while the appeal was pending, I would argue that it isn't waived. But
but the issue isn't waiver so much as ineffective assistance. How could it be ineffective assistance not to raise an argument that didn't come out until later?
Well, I suppose I could make an argument under the clairvoyance exception.
I think you also would figure out that it was in a concurring opinion. That seems like an awful lot to ask.
Well, it was, again, prior counsel did raise it, so I'm not, it was there. The decision in Justice Milkey's concurrence came out. My sense is that overall that, I was the petitioner, I represented the petitioner in that case, and because it was a favorable result, we did not appeal. The board did not appeal it, so it went back down to the hearing level. It's banging around. It's gonna make its way back up. Frankly, this issue with Factor 2, it is partly just flat out wrong on the science, and it is it's going to come back up, and my client should not be prejudiced. In the interest of fairness, my client should not be deemed as having waived that case or waived that argument.
All right. Thank you very much. Let me just check and make sure that the no further questions I see from Justice Milkey, no further questions from Justice Dickoff. Thank you very much for your argument. Now we'll turn to Attorney Bossé.
Your Honor, good morning. May it please the court, John Bossé for the Sex Offender Registry Board. As the court knows, prior to the classification hearing, Doe's counsel filed a motion for expert funds, and the expert was so that the motion was so that an expert could administer the static 99R to Doe and testify to the results. And it's SWORD's position that the hearing examiner properly denied the motion for expert funds because, as the Supreme Judicial Court said in Commonwealth v. George, the static 99R cannot estimate risks to reoffend for a specific individual. Actuarial tools such as the static 99R can only estimate risks to reoffend based upon group estimate.
Counsel, isn't it also true, though, that there is some play in the scoring of a static 99R or the other test that was used here? And if so, and if the hearing examiner may rely on all of this, why isn't a plaintiff entitled to have someone do his own scoring?
Mm-hmm. Sure. So again, it's because the static 99R cannot identify risks to reoffend for a specific individual. The SWORD's classification process is more comprehensive and detailed than the static 99R.
No, Counsel, you're making it sound like this information is irrelevant. The hearing examiner clearly didn't think it was irrelevant. Query how much weight she put on it, but if it hadn't been relevant, the board wouldn't have introduced it at the hearing. Why doesn't the sex offender get a chance to submit his own scoring?
Mm-hmm. Well, in this case, the hearing examiner could consider the results under Factor 35. And in a recent case from the appeals, actually from the Supreme Judicial Court that I submitted a 16L letter on, it said that the board need not, the board does not have to allow expert funds on regarding an issue that the board's regulatory factors already address. So Factor 35 allows a hearing examiner to consider actuarial risk assessment tools such as the static 99R and the Sable 2007.
But why doesn't that undercut your argument? If they can rely on that factor in part, notwithstanding it's the group and not the individual, if there is play in how these tests, if you will, are scored, why doesn't he get the opportunity to do his own analysis?
Because, well, one, it's not specific to the static 99R is not specific to the offender. And number two, in this case, the hearing examiner mentioned the results of the static 99R and the stable 2007, but she didn't place any, she didn't mention them in her discussion of the case. She mentioned them briefly under factor 35, but she didn't mention them in her discussion of the case. So our argument is that she didn't place any significant reliance on the test results of the static 99R and the stable 2007 under her discussion of the case. Her discussion of the case focused on Doe's history of sexual misconduct, as well as his progress in sex offender treatment. And with respect, so that concerns the denial of motion for expert funds. With respect to the risk category labels of the stable 2007 and static 99R that Commonwealth v. George addresses, the SORB acknowledges under Commonwealth v. George, hearing counsel could have objected to the risk category labels coming into evidence. However, once again, the hearing examiner briefly mentioned the risk category labels of the static 99R and the stable 2007, and didn't place any significant reliance upon the risk category labels under her discussion of the case. And besides the, so she didn't place, they were briefly mentioned under factor 35. And again, the hearing examiner's decision focused on Doe's sexual misconduct prior to his incarceration, as well as his sex offender treatment. And that's why that even if this court were to find that hearing counsel committed ineffective assistance of counsel by failing to not object to the risk category labels, there's no probability that Doe would be classified below a level 3 sex offender based upon his history of sexual misconduct and the additional information that was revealed about him through sex offender treatment. And I discussed that in detail under argument 3 of my brief. Does the court have any questions? If not, I would rest on my brief.
I have one question.
Sure.
Which is, I noticed that you did not argue that something that was raised in front of the examiner but wasn't raised in the Superior Court is waived. And I was wondering whether that's a sore position or just something you didn't want to get into on this appeal.
Oh, sure, Your Honor. So there was a few arguments that weren't raised in front of the hearing examiner. Actually, one argument, it was Doe's motion for expert funds only asks for expert funds so that an expert could administer and testify to the results of the static 99R. The motion for expert funds did not ask for an expert witness so that the witness could testify whether Doe's conduct was compulsive under factor 2. And because that argument was not raised in the motion for expert funds before the hearing examiner, as well as raised before the Superior Court, it's SORB's position that that argument has been waived.
But I think Judge Ditkoff's question went to the opposite, namely the challenge to the denial of expert funds was not raised in Superior Court, yet you don't appear to have argued that that was waived by the failure to argue it in Superior Court.
Well, it was raised before the hearing examiner. So if I'm incorrect, as long as you raise it before the administrative agency, then it's not waived unless you have to raise it before the administrative agency and the Superior Court. So if the decision law says you have to raise it before the administrative agency and the Superior Court, then SORB's position would be that the issue is waived.
Okay.
And the claims of ineffective assistance of counsel were also never raised. You know, the plaintiff, the appellant in this case, never asked for a stay in this court while he pursued the claims of ineffective assistance counsel in the Superior Court, which, based upon decisional law, the SORB believes is the appropriate mechanism, which didn't occur in this case. And we do cite to case law in our brief to support that position. And in closing, again, even if there was ineffective assistance, even if the hearing examiner should have allowed those motion for expert funds, there was no prejudice because of the strong evidence of Doe's sexual misconduct while he was in the community, and the additional evidence that we learned about his sexual misconduct while he was in treatment. And for those reasons, the SORB respectfully requests that this court affirm the level 3 classification. And unless there's any further questions, the SORB will rest on its brief.
I see no further questions at this point, so thank you very much. Thank you both of you for your arguments. They were very helpful. We'll take the case under advisement and get back to you as soon as we possibly can. And meanwhile, the panel wishes everyone stays as safe and healthy during these times. Marianne Buno. A couple of preliminaries. Attorney Sacco, you have 15 minutes to present your argument. And on the other side, I understand that Attorney Freeman will be taking 10 minutes and Attorney Haskell another 5 minutes. You can be assured that we have reviewed the record carefully and that we consider it beneficial if you get right to your most important points during the course of your argument. The last reminder is that I think all of you have appeared before us on this remote platform before. Perhaps Attorney Sacco, you have not, I'm not sure. But so far, we've achieved great success. It works very well. We have, upon occasion, had some technical difficulties. And if we have any today, we expect your patience. And you can be assured that we will return the favor and be patient with you as well. So with all that said, I'll call this case, our fourth case on the list, Stoneham Retirement Board and others versus the Massachusetts Teachers Retirement System, as well as PURAC, as well as CRAB. 2019-1389 is the number of the case. And Attorney Sacco, the floor is yours.
Thank you, Your Honors. May it please the court, Michael Sacco on behalf of the plaintiffs. Plaintiffs are appealing the dismissal of the complaint that was filed. It was a 2-count complaint seeking a declaratory judgment as well as a violation of the contributory retirement laws pursuant to Mass General Laws, Chapter 32, Section 24(1). Plaintiffs advanced 3 arguments on appeal. The first is that the complaint, as I noted, contained 2 counts, but the motion to dismiss that the MTRS filed only addressed the first count and based on exhaustion of administrative remedies. So we believe the Superior Court erred by dismissing the entire complaint. The second argument that we'll advance is that in this case, we don't believe there's any requirement to exhaust administrative remedies. And the third, we question whether CRAB even has jurisdiction on this particular matter based on the statutory construction. With respect to the first argument,
Can I just ask you one question, a procedural matter, before you go into your full arguments? And that is, the proceedings are still ongoing in before the administrative bodies. Is that correct? In other words, I see there was a motion to stay the proceedings that was filed in August of 2019, it appears, or at least the motion to stay was denied in August of 2019.
That's correct.
Am I right about that?
That is correct, Your Honor, not only with these 4 plaintiffs, but there are a myriad of other retirement boards that have matters pending before the Division of Administrative Law Appeals and CRAB. We have sought, I represent many of them, we've sought stays in all of them, and they've been denied in every case.
So with respect to these particular plaintiffs' boards that you're representing now in this case, what's been going on in the last year? Has anything developed that we should be aware of?
Well, there have been decisions in, I believe, the Clinton case, which Dalla has ruled, again, similar to other cases, that the statute of limitations contract argument doesn't apply, that the
Okay, I guess I'm not really asking you to go into any of the detail about what's not before us. So I don't want, but I just was wondering procedurally, those cases had been going on at the same time that this litigation has been going on. Is that correct?
That is correct, Your Honor.
Okay, and so I guess that behooves the, excuse me, go ahead.
No, but just where is the Clinton case then as we speak?
At Crabb. So there's been a Dalla decision, and and there's also been a Dalla decision on the Waltham case, I believe, Your Honor, and both of those are pending at Crabb. So then
you took an appeal. You took an appeal from the Dalla ruling and went to Crabb.
Yes, Your Honor.
Okay. So this, I guess, goes right to one of your issues, which is the exhaustion administrative remedies. Right now we have, as we speak, 2 ongoing proceedings.
So with the exhaustion argument, Your Honor, and I think this was mentioned most recently in Green versus Zoning Board of Appeals versus Zoning Board of Southborough, which I think Justice Milkey sat on that case. There are 5 exhaustion requirement exemptions, whether the remedy is inadequate, whether it's an important, novel, or recurrent issue, whether the decision has public significance, whether it's a question of law, or whether it's futile. What we've suggested in this case is that many of those apply here. Crabb has already ruled, it's part of the appendix, and the MTRS has argued that essentially we have no case because Crabb has already ruled on the legal question. So
how is this novel then? Why isn't that case why isn't that the case that case continue on appeals so you can have a decision with respect to what's going on?
The Crabb had previously, before any of these 4 cases were brought, Crabb had previously ruled that the contract language in Chapter 32, that they had concurrent jurisdiction, which we disagree with, which is a question of law. So we're essentially being forced to go back through an administrative appeal process with these 4 cases, Your Honor, with a foregone conclusion. Dalla is bound by Crabb. Crabb has already ruled that as a matter of law, that the contract language in Section 38C is not exclusive and that they have jurisdiction. So to require, which we think is the essence of futility, because we cannot possibly get a different result going through Crabb. And it is a novel question in that Crabb taking the position that it has jurisdiction on a matter where the legislature has said exclusively, and as the SJC reported in the Woodward decision, which was mentioned in my brief, that there are certain areas of the law in Chapter 32 where jurisdiction was conferred on the Superior Court, mentioning Section 38C, which is what this case is about. So we believe that is relevant to this, and that is why we have the ability to circumvent the administrative process in these cases, because Crabb has already decided the legal question.
Is Crabb not allowed to change its mind?
I'm sorry, Your Honor, I couldn't hear you.
Crabb allowed to change its mind? Is it allowed to, on better arguments, say, wait a second, we're not going to rule the same way we rule previous? I know Dalla has to follow Crabb, but
Crabb can change its mind, Your Honor, but I would point to the stays that we filed in this case, in other administrative cases where Crabb has declined to stay the case, and they've already issued a decision once. While they certainly have the ability, and I've been involved in 30 years of doing this, I've been able to change their mind once, and while I certainly have confidence in my powers of persuasion, they seem pretty set in their ways on this one. So it's possible, though, that they could change their mind, but they don't appear to have any interest in doing so in these particular cases. And while it's, and I don't mean this to sound trite, but while it's wonderful for my practice to keep litigating the same case 10 times, it makes no sense. And that's why we believe that we need to have an answer on this case and on this particular issue.
Well, let me ask you this, and another follow-up on the procedure here. The case that we were referring to earlier, where CRAB has ruled on the same issue and with a different plaintiff. I think that's the case we were talking about that was in your appendix, is the Lynn case. That's on page 43 of your appendix, right? Is that what you're talking about?
Yes, Your Honor.
So what was that? What happened with respect to that case?
That case went to the Superior Court, and the Superior Court affirmed the CRAB decision.
And then?
And there was no further appeal taken.
Okay.
And I'd also note, while on the exhaustion issue, Your Honor, the Polonzi case that I cite in my brief was very similar in that it had to do with police chiefs trying to use the personal use value of their motor vehicle. It actually was my case that I argued at the SJC. And in that case, because CRAB had already issued a decision on the legal question, Mr. Polonzi brought the matter straight to the Superior Court. Superior Court took jurisdiction, issued a decision. There was an appeal that was taken to the appeals court, and the SJC took it sua sponte, and never once was there a question as to whether or not the administrative remedies had not been exhausted, which clearly they had not. And the reason for that is because CRAB had already ruled on the legal question. We're not seeking some broad exemption here, Your Honors, with respect to the exhaustion question, and to suggest that every legal question, which as the court knows is de novo in front of the Superior Court as well as the appeals court and the SJC, we're not suggesting that every legal question allows a retirement board to circumvent the administrative appeal process. What we're merely suggesting is that it is a futile exercise to go back before CRAB, where it has already ruled on the case and made a decision, several now, as a matter of law, that Section 38C does not require, in this case, the MTRS to seek its remedy via the Superior Court through a contract action.
Counsel, you focused on the procedural aspects of this and whether or not the 6-year statute of limitations applies. Isn't there a more fundamental substantive question in terms of if it applies, how it applies? And, you know, we're being asked to harmonize a bunch of disparate statutory provisions here. Why isn't the obvious way to harmonize them to say something like, of course, the statute of limitations applies, but it doesn't begin to run until there's been a determination of the respective substantive shares that each retirement system has to pay. And that can't happen until CRAB resolves the current proceeding.
Well, Your Honor, I respectfully, I don't think that is how the statute is worded. When it talks about Section 38C, PERAC, the oversight authority, makes a determination as to the second retirement board, what they owe the first retirement board. And then the statute specifically says if the retirement board doesn't pay its bill, that the first system has a right to take an action into the Superior Court and contract. There isn't
and it's at that point that the statute begins to run. I'm hypothesizing that would seem to be a rational interpretation of the statute.
Yes, Your Honor. So what we're suggesting is the MTRS, which has filed a series of appeals, all of these 4 cases are an appeal at DALA, that the MTRS should not have gone to DALA. They should have gone to Superior Court. They haven't done that. They've gone to DALA because DALA and CRAB have accepted jurisdiction over a matter that I would suggest to you that they don't have jurisdiction over.
But I thought your argument was that the 6-year statute began to run from when the payments would have been due a long time ago.
Right.
Well, the argument I made, Your Honor, which I hope was clear, was that the 6-year statute runs when we're first presented with the bill. In other words, we were first presented with the invoices in 2017, and thus the MTRS could only ask for payments that go back 6 years from that point.
No, that's not what. But you're saying that when you're presented with the bill, that's not when the clock starts running. You're saying the clock's already run and you can only go back 6 years.
Well,
I'm saying, why doesn't the clock begin running, in this case, as of 2017?
so that, if I understand your question, Your Honor, you're suggesting that when the bill was presented in 2017, that they had an additional 6 years to.
Well, that's the first time everybody knew what your share was, wasn't it?
It was, but we should have known back in 2010 in one case, in most cases, but in one case, 1999, someone retired, and we're now learning in 2017, almost 20 years later, that we owe tens of thousands of dollars to the retirement system. So it seems to me that the statute starts to run, the 6-year statute of limitations runs when the MTRS says they have a cause of action, and they had a cause of action when we were first billed in 2017.
How could MTRS file this contract suit under 3.8c before the amount's been determined by CRAB?
CRAB
A
doesn't
more
have to-
articulate version of my question.
Whoever determines it. It's
So-
still talking about the actuarial. How can
Right.
they file a 3.8c action?
So they would, what happens procedurally, Your Honor, and what happened in this case was in 2017, PERAC, the actuary, informed for the first time the plaintiffs that they owed money to the MTRS. That's their determination to make, not CRAB's. They made that determination. The plaintiffs paid what they believed they owed, which was 6 years of payments from 2011 to 2017.
And that was the first point that MTRS could have filed a 3.8c action, right? Once you
Correct.
did a partial payment. So how can the statute of limitations start running before they have a cause of action under the statute?
I guess, Your Honor, what I'm suggesting, and perhaps incorrectly, if you're going to tell me, is that that they had, they should have submitted the information to PERAC the year the individual retired. So in this case, in 2008, 2009, 2010, and in one case, 1999, they should have submitted the information to PERAC. PERAC would have submitted a bill to the plaintiffs the following year. They would have paid it. What
So
happened?
you're
in this
saying that, go ahead. I'm sorry, you're saying the statute of limitations always has to begin upon the retirement of the when the retiree critical service is over and is on and begins to receive pension.
Yes, the statute contemplates that when someone retires, that, and this is how it works, when someone retires and that person has rendered service in more than one retirement system, the retirement is submitted to PERAC. PERAC makes a determination between the multiple systems, who owes how much money, and communicates that information to the retiring system, who then in turn issues an invoice to the other retirement systems for reimbursement for that person's retirement.
Isn't your argument more like latches, more like the board should have done something earlier rather than the fact that there's a statute of limitations that runs?
It is sort of a latches argument as well, Your Honor. I see my time has expired, but I guess what I want to end on, Your Honors, is that the complaint should not have been dismissed at this early stage, particularly on the 24-1 claim, which clearly the court has exclusive jurisdiction on that claim, and thus there could be no exhaustion argument advanced to have that claim dismissed. So we'd ask that the court reverse and remand this back to the Superior Court.
Did you ask for direct appellate review from the SJC in this case?
We did not, Your Honor.
Okay, thank you. Let me see if the panel members have any other questions.
I just have
Seeing
one.
none.
I just have
go
one
ahead.
technical question.
Sure.
These retiree teachers, they had prior non-teacher employment with the various government agencies. Is that what's going on?
That's right. That's right. Many teachers start out as paraprofessionals or teachers' aides, become certified, and then once they do, they qualify for membership in the teachers' retirement system, and the plaintiffs would transfer the credit and the money that they collected to the MTRS.
Right, thank you.
You're welcome, Your Honor. Thank you.
Okay, thank you very much. So next we'll hear from Attorney Freeman, and that will be for 10 minutes.
I'm just waiting for my clock.
Sure. Yep.
There we go. There we go. All right.
There you go.
Members of the panel, may it please the court, Ashley Freeman for the co-defendant appellee, Massachusetts Teachers Retirement System. Good morning. We're here today to speak upon the dismissal of the plaintiff's action from the Superior Court for failure to exhaust their administrative remedies. Administrative remedies which were already underway for several months before the plaintiffs brought their case, and indeed brought their case to try and just interrupt those ongoing administrative processes. Now, the court was correct to dismiss this case on 3 grounds. First, 3AC does not grant the plaintiffs a cause of action to seek declaratory relief from the Superior Court. The courts have said that all parties must exhaust their administrative remedies before seeking relief from the court, before seeking declaratory judgment from the court. Second, Section 16.4 does grant primary jurisdiction of retirement matters to Dalla and Crabb. And finally, the plaintiffs just don't qualify for any of the exceptions to the doctrine of administrative exhaustion. They don't qualify for the futility exhaustion, and they don't qualify for Section 24.1, which was enacted by the legislature, but with very narrow requirements for parties to be able to use that to access the courts.
Is Mr. Sacco wrong when he says that we know how Crabb is going to rule on this?
I think that he could be wrong, and I think that is Crabb's place to decide upon. Crabb does change its mind. There could be factual issues in these particular cases that could distinguish it from previous cases. Obviously, the MTRS does not think so. The MTRS does think that they have the law correct, but that is ultimately Crabb's place to decide, not a petitioner's position to decide how Crabb's going to call.
But why isn't the question of whether the statute of limitations applies, and if so, how, a pure question of law that is going to be up to the court?
The language, an action and contract is laid out by Section 38C, which is, of course, in Chapter 32. The power of an action and contract is set out by Chapter 32. And all Chapter 32 matters, it falls under the umbrella of Chapter 32, which the legislature has given primary jurisdiction of Chapter 32 to Dalla and Crabb. So in this matter, it's not a contract law matter. This is a Chapter 32 matter, and it should be seen by Dalla and Crabb first.
Well, what are you saying, that there is no statute of limitations that applies here?
That is correct. We're saying that the statute is clear on its language, that the retirement system should be paid in full, and that an arbitrary statute of limitations, which is not laid out in Chapter 32, would interfere with that language. That's
what is wrong with the interpretation that was offered earlier in terms of looking at this case, that the 6-year statute of limitations would apply in 2017 when PIRAC made its ruling on how the apportionment should happen?
Well, I think it's incorrect to apply any statute of limitations to this particular case. I would direct the court to the Lexington case, which I cite in my brief. That pretty well goes into what an action and contract means within the statute, within Chapter 32. It means that remedies of a contract are available, not that the elements to create a contract must be met. And so when Chapter 32 says an action contract, it does not mean that it will place all of the strictures of contract law upon Chapter 32, in which case the statute of limitations of contract law is just misapplied in this case.
Disagree with the proposition that once they refused to pay the full amount, you had the choice to either take a 16-4 appeal or to file a contract action under 3HC.
I'm sorry, Your Honor, did you ask if I agree that the MTRS has the choice?
Yeah, do you think you had the choice between those two, or do you think you had to go 16-4?
I think Your Honor is correct. The MTRS, being the first governmental unit in this case, does have the choice whether or not to pursue an action contract through the courts or to follow through with the administrative process in Dalla and Crabb. And obviously, the MTRS has chosen in this case to go through the administrative process.
So what limitations, if any, are there on the paying retirement system in terms of when it has to bring a claim? Could it wait for another 10 years before?
I don't think that that would be my place to decide. I think that's CRAB's place to decide. However, CRAB has said that there's no statute of limitations, contract statute of limitations or otherwise. DALA has said, and CRAB is upheld, and so is the Superior Court, that payment must be made in full. And so following that line of reasoning, payment in full means payment in full with no limit on time when the money is requested. That is correct, Your Honor.
So there could be a 20-year gap between the time of credible service and between the time a bill is actually presented to a retirement system.
Yes, Your Honor.
Or more.
Yes, Your Honor, that is correct.
And I guess the point, if I don't want to put words in your mouth, would be is that this is an entirely intricate system that's set up, and it would be difficult to take one piece of this at this point, at this juncture, and change that. That if it was to be determined that that seemed to be very difficult for small retirement systems that are paying in and suddenly get a huge bill, that would be something that the legislature could address rather than DALA, CRAB, and then the appellate court.
Yes, Your Honor, that would certainly be something the legislature could address. I will point out in this particular case for these four plaintiffs, at least for Clinton and Waltham, and definitely for Clinton, the four plaintiffs, or at least those two definitely, did have notice when these particular employees retired that they had 380 liability. So even in a couple of these cases, possibly all four, we haven't gone through the merits of the other cases. These four retirement systems did have notice at the time. So it's not like this three.
Okay, but what were their remedies at that time when they learned of this? Could they have gone to PIRAC and say, we know these are hanging out here. We don't think we're owed more than X%?
Yes, most certainly. They could have sought a determination from PIRAC, and retirement boards often go to PIRAC for a determination on complex legal matters. They could have even appealed directly to DALA if there is a piece of the statute that says inaction by a board can be appealed. So once the boards realize
you said inaction, excuse me, you said inaction. No, okay.
Yes, inaction from a board, that's correct. If a board does not act, someone or a board could appeal that. So if these boards, at any point thought that, something was going on that should have been acted on, they could have appealed directly to DALA at that point.
But I'm a little unclear how an appeal would work when there's no action. Could they have initiated a petition with PIRAC saying, this is what we think our share is?
Yes, they could have. They could have written a letter directly to PIRAC, asking PIRAC to weigh in on an issue, saying, this is what we think. Would you please make a determination on how we should proceed? And then if the boards are, don't like the PIRAC determination, then they can appeal that too. They can take that determination and appeal that as well.
Okay. Yeah. I don't see any other questions. Do I see any other questions? I don't see any. Attorney Freeman, you still have a minute if you want to sum up. Otherwise, I don't see any questions from the panel.
Great. A couple of things, two things really quick. First of all, I want to address the Polonzi case. I will direct the panel members' attention to footnote, I believe it's 6 in that particular case. At that time, DALA was not scheduling cases of that matter. So I would recontextualize that particular case as a futility argument, why the Superior Court allowed that case directly into the Superior Court without having to finish the appeal process in front of the administrative body, because DALA was not hearing those cases at that time. At that point, the administrative remedy was not adequate. And that is the last point I have to make. I urge this panel respectfully to uphold the correct dismissal of this case from the Superior Court. And with that, I will rest upon my brief. Thank you.
Great. Okay, thank you very much. One moment, Attorney Haskell, when we have your time come up, you can begin your argument, okay? There we go. You may start.
So thank you, and may it please the court again. My name is Eric Haskell. I'm an assistant attorney general, and we're here representing PIRAC, not CRAB. We're here on behalf of the Public Employee
I apologize.
Commission. PIRAC wasn't initially a party to this suit in the Superior Court. It allowed itself to be joined as a party, and it's here today to express a particular view, not so much about the underlying dispute between the plaintiffs and MTRS, but rather about PIRAC's interest in the integrity of the efficient and good administration of the retirement system. From proceeding from that point of view, PIRAC's view is that the statutes don't bear the weight that the plaintiffs are asking them to carry, in the sense that the plaintiffs are looking for a right of action and contract under 38C that isn't provided by that statute. They're looking for an equitable right of action under 24 sub 1 that doesn't exist under that statute. Yes.
Counsel, at the point that your client ruled and set the apportionment of everyone's share, couldn't a contract claim have been brought at that time?
At the time that PIRAC performed the calculation?
Yes.
Yes, that in our view was.
Why wouldn't a 6-year contract statute of limitations start at that point?
To the extent that 38C provides a right of action and contract, and to the extent that the contract statute of limitations under 260 section 2 applies, which is something that Ms. Freeman spoke about a moment ago, we don't disagree that probably was the time from which the 6 years ought to be measured. Our concern, though, is, I guess, twofold. First of all, the right of action under 38C benefits a retirement board in the position of MTRS in this situation, not a retirement board in the situation of the plaintiffs in this case. And second, and relatedly, you see this in the way that the plaintiff's cause of action is kind of styled as an affirmative, not a defensive use of the statute of limitations and the contract right of action under 38C. It goes back to something that that was discussed during Mr. Sacco's argument, and that's the function of the 6-year statute of limitations here. Now, Judge Ditkoff, during Mr. Sacco's argument, asked a question about how the statute of limitations really works for the plaintiffs here. And Mr. Sacco's response, I took note of, was that the MTRS should have submitted these reimbursement requests to PIRAC sometime earlier than it did. That's fine. That's the underlying dispute in this case. But PIRAC's point is that that dispute about when the request should have been submitted, when the reimbursement calculation should have been performed, those are important issues under Chapter 32 that are squarely within the expertise of CRAB and the administrative authorities who know that system. And therefore, the dispute between the plaintiffs and MTRS ought to have been submitted to the administrative system for adjudication. Our concern is that what the plaintiff boards have tried to do here is in some ways an end run around that system, and that a rule permitting the plaintiffs to bring an action of this type would ultimately do violence to the efficient and sound administration of that system. And for that reason, we believe that the Superior Court got it right and ought to be affirmed. Unless there are questions.
But why isn't the question of when the 6-year statute of limitations starts, assuming it applies, a pure question of law, which is different from the pre-PIRAC ruling issues you were just discussing?
I think that is a pure question of law. But again, first, the issue of whether the statute of limitations applies to the right of action created under 38C in view of the Lexington case. This is what Ms. Freeman spoke about earlier. really is an issue under Chapter 32. It's an issue of the administration of the retirement system. And then second, the scope of the right of action under 3.8c only benefits a system in MTRS's position here. It doesn't benefit a system in the plaintiff's situation in this case. And for that reason, we don't think really advances the ball for the plaintiffs.
Justice Milky, any follow-up on your behalf? No? Okay. Justice Dipkoff, no questions from you. Thank you all three of you very much. This is an interesting case, and we'll take the case under advisement and try not to prolong things that have already been prolonged as far as you're concerned. Attorney Sacco, and get an answer back to you as soon as we possibly can. All right. And meanwhile, the panel wishes all of you a
We're live.
Thank you very much. Okay, it's just before noon, so I'll still say good morning to all of you and welcome you to today's remote sitting of the Appeals Court. Joining me today on the panel is Justice James Milky and Justice Joseph Dipkoff, and my name is Ariane Buno. Just a couple of reminders. Attorney Foster, you have 15 minutes to present your argument, and with respect to our other two attorneys, the division is going to be 8 minutes and 7 minutes, correct? All right. You can be assured that we read the record and we know the issues that you're presenting, and so we suggest that you get right to your most salient points. And lastly, I want to remind you that we've had great success with this platform, and we're very happy and appreciative to be able to use it so that everybody can stay safe and remote during the course of the proceedings, but we do upon occasion have some technical difficulties. And if that happens, we ask your patience, and we'll be patient as well. So with that, I'm going to call the case, remind you all that it's impounded and that we are live streaming to the public. Case number 2020-0379, Department of Children and Families versus Mother and Another. So Attorney Foster, please begin.
Good morning. May it please the court. I am Attorney Catherine Foster on behalf of the appellant mother in this case, who challenges the termination of her parental rights because the evidence in this case does not rise to the level of clear and convincing evidence of current parental unfitness. The focus in this case should have been on what changed about mother's parenting to make her unfit at the time that she left her son with his grandmother, not on why mother was unfit before her child's removal, because she wasn't. It is not permissible for the court to terminate a mother's rights to her only child by reframing historical information provided by DCF that did not even support removal at the time. And when the court picks out only the negative information while ignoring more positive information in the same documents. DCF argues that the trial court was not compelled to comment on every piece of evidence when the information contained in the department's investigations had limited evidentiary value because it was more than 3 years before the child's removal. But DCF can't have it both ways. Either the information as a whole is of limited value, or the court has to look at both positive and negative information in the same documents to show that it even-handedly assessed the evidence and confronted any troublesome facts that it countered its decision to terminate parental rights. The court also weighed its perception of mother's credibility too heavily to support termination, and in the process neglected its role as the fact finder. If this court is going to rely mostly on a parent's credibility to find that parent unfit, then the court has to do a rigorous job to find facts to support that decision. Here, where a number of the court's findings are clearly erroneous, taken together, the decision cannot support termination of mother's parental rights by clear and convincing evidence. For instance, the court erroneously found that mother used marijuana against her therapist's wishes. When her therapist testified that she wasn't working on quitting marijuana with mother, where mother's health records repeatedly show that the therapist reported she was doing well in her recovery when she had negative screens that were negative for opiates, but positive for marijuana and methadone. The court relies on a hypothetical posed by DCF to find that the therapist did not condone this marijuana use, but on page 966 of the transcripts, the hypothetical is posed and the therapist says, I don't know how to answer that. I guess I wouldn't condone it. But 13 pages later, the therapist says on page 973 that she's not working on that with mother. So with regard to this particular parent, the issue of marijuana was not a problem according to her own therapist, which the court qualified as a clinical expert. The court also erroneously found mother was encouraged to attend NA and AA, but failed to. This directly contradicts the therapist's testimony. The court overlooked the agreement and testimony among all parties that mother participated in treatment from June 2018 until the trial, and found that she didn't participate until May 19. The court inappropriately relied on cleanliness and suitability when the department found mother to have a clean and safe home environment, when they found no safety issues, even in January 2019, even right before the trial. Somewhat alarmingly, the court also finds that mother was emotionally unavailable to her child. First of all, I think if that's going to be a factor for finding a parent unfit, then probably no parent is safe. But beyond that, the court's determination ignores the repeated reports by DCF of mother's bond with her son in 2008, in 2011, in 2013, in 2016, and beyond. If mother was emotionally unavailable to her child, she would not have an easily observable bond. The court makes a lot of the fact that mother had an admitted long-term struggle with drug addiction. But the fact that she struggled with drug addiction while caring for her child doesn't mean that she was unfit. Adoption of Catherine makes it really clear that a parent can struggle with drug addiction, but it has to be more than that to find a parent unfit.
Counselor, in this case, the child jokes that it's funny that mommy can't get up. Your client brings the child to a methadone clinic. Your mother gets terminated for stealing methadone from Spectrum. And the child, she's very good at hiding his problems, but once he's with the paternal aunt and uncle, we find out he has all kinds of emotional problems. We find that his teeth haven't been cared for, and those problems are very hard to deal with. So why isn't that give us the nexus between her drug use problems, which seem to continue all the way to trial, and her parenting?
Well, several issues, but I would say first, mother wouldn't say she's a perfect parent, but she was a fit parent. Even if she had moments with her child where he did notice her struggles, that doesn't mean she was unfit. Also, the child's emotional struggles stem from his sexual abuse at age 5 by paternal great-grandfather, when he started having problems with controlling his feces and things like this. And these problems did continue after he was removed. But mom took care of that. As soon as she realized it happened, she brought the child, they had a SANE interview, she brought the child to DCF. The child disclosed the abuse to DCF. The child was in therapy at school weekly after that happened. That is the response of a fit parent. Bringing her child to the methadone clinic, what else was she supposed to do? She couldn't leave the child at home. If a parent is struggling with drug addiction, the priority in order to be a fit parent would be to get the methadone. So I guess the fact that she was able to parent well prior to the removal, despite admittedly struggling with drug addiction, tends to weigh more towards fitness to parent, even in challenging circumstances, rather than unfitness. And additionally, this case is challenging because it feels more like a custody case in terms of the hard time that the paternal and maternal families had dealing with each other. And very clearly, paternal family was not fond of mother and said many negative things. It's unclear how often they said these things in the presence of her child. It makes it hard to see or to discern truly where the child's emotional concerns after removal come from. But I think there's evidence to support, especially to support mother's fitness before, especially when you look at his school records. In the record, pages 414 to 420, the report cards, they're seamless. They were positive when he was in mother's care. They're positive after he's removed. He has DCF reports some struggles during the transition, but he always has positive report cards. The worst the court can say is that he was a little behind in spelling. But lots of, that's not a sign of parental unfitness. So in this case, mother suggests that it wasn't enough for the court to rely on finding her not credible when there was so much evidence of fitness in the record. It was not appropriate for the court to pick out the negative information and ignore the positive information, because without support of facts in the record, credibility isn't enough to rise to the level of clear and convincing evidence of parental unfitness. Wherefore, unless the court has other questions, mother respectfully requests that this court remand to the trial court for further hearing on the issue of her fitness and any other relief that this court deems appropriate.
Okay. Thank you very much. I see no questions from the panel, so we'll go on now to hear from Attorney O'Brien, right? Or did I call the right one? Or Attorney Lynn, Attorney Murphy.
Usually
yes. Yep, yes. Attorney Murphy first. Thank you. So now we've twice had put you in the wrong order. Wrong room first, now the wrong order. But I apologize. So Attorney Murphy,
oh, no problem. Yeah, very good. Well, good afternoon. May it please the court, Lynn Murphy for the Department of Children and Families. This is a case where the court was faced with determining the best interests of a child whose mother had an extensive history of substance abuse and the chaotic lifestyle and unsafe environment that often accompanies people that suffer from such issues. The trial court properly determined that it took mother 3 years. Well, the case was open for 3 years, and mother did not cooperate with the department until 6 months prior to trial. She made very little effort to follow any of the services. She did not address her substance abuse in a consistent manner. And even at 6 months prior to trial, there was an improvement, which the court did note. The court did not ignore all positive evidence of mother and actually noted that she was doing much better with her treatment and in participating in treatment and commented positively on that. But the problem was that the story doesn't end there. Even though she had made attempts, she still was missing many of her group therapy appointments, her individual therapy appointments. She wasn't consistent. And even maybe more telling, she wasn't progressing through the program. She was only at level 2, despite an entire year. She had only gotten to the 2nd level, and there's 4 levels to complete the treatment. So the court was understandably concerned that mother's sobriety was in her treatment was just in the very initial stages. She, again, the court looked at the whole picture and 12 or more years of significant substance abuse. And her treatment attempts up to that time had never been successful. She did not even have a relapse plan at the time of trial. And even more concerning, she still was unable to acknowledge the role that this substance abuse played in her life and the harm that it caused her child. She still was, in fact, I think in one of the questions the judge asked, she said she didn't think that I'm sorry, not the judge, but on cross-examination, she was not able to understand that the CMP was the result of her substance abuse. And the court clearly was appropriately relying on this long pattern of substance abuse and inability to, her many treatment attempts at treatment had never resulted in any long-standing change. Now, during the 3 years, there's a question. Okay, sorry. So during the 3 years that the CMP was pending, now this child developed a very strong bond with his maternal uncle and aunt. And at this point, not only was the child harmed in her care, and there was expert testimony about the PTSD that he did suffer from, and not only would mothers lack of following services and actually dishonest dealings with service providers, not only would this inhibit mother's ability to handle the child's special needs, but now we have a bond, very close bond, that would be very disrupted. Again, expert testimony showing that the child would be harmed, and now you have an additional special need on top of his special needs that he already had. Again, PTSD, he had anxiety. So termination was absolutely appropriate. This child needs and was begging actually for stability and to remain with his maternal uncle and aunt. And I think the record is very clear. And I won't get too much into the child's issues because I think Attorney O'Brien will be dealing with that piece of it. So if there are no questions, I would rest on my brief and ask this court to affirm.
No questions then. We'll wait for the timer to change and we will hear from Attorney O'Brien. Attorney O'Brien, just so you know, your mute button is still on.
Yes, thank you. Thank you, Your Honor. May it please the
Just
court.
wait. There you go. Now you may, please begin now. Sorry to interrupt.
Morning, Your Honors. May it please the court. Gary O'Brien on behalf of the child. I think the department's counsel kind of went through the main issues with regard to unfitness and best interest and why the trial court was correct in deciding to find the child in need of care and protection and terminate parental rights and find mother unfit. I think the basic kind of just summary of from our brief, there were the real issues that the trial court found were mother's long history of substance abuse, the effect it had on the child, the mother's lack of engagement in treatment for substance abuse, her failure to provide information to DCF to verify services, her unwillingness or inability to understand the impact of her substance abuse upon the child, her criminal history and involvement with quote wrong people as the court found, her lack of credibility with both DCF and the court, which I think in terms of mother's arguments went a long way, as the trial court found again and again, as we pointed out in our brief, mother's lack of credibility, or the court just didn't credit certain parts of her testimony. And then in terms of the child, his express preference over time that he be adopted and be able to stay with his paternal uncle and aunt. Finally, the child's therapist, who testified extensively in his expert opinion that the child would suffer irreparable harm were he be removed from his current home and returned to mother. So I think all of those were overwhelmingly clear and convincing evidence that the trial court was correct, and this court should affirm that decision. I think the case, as we pointed out in our brief, is very much akin to Elena, where the mother had started to make some treatment, but still, as the department's counsel pointed out, was in the early stages of treatment, and still not in a position for the child to be back in her care, and was still at that point unfit. And so I think for all those reasons, this court should affirm the decision of the trial court. I think for all the reasons we've stated in our brief. I don't know if the panel has any questions for me. I think I would otherwise just go over the same grounds that the department's counsel has already laid out. And I know that the panel's read our briefs and familiar with the issues, but.
I just have one question, counsel. How do you address Attorney Foster's argument that the judge placed too much reliance on the department's views of the mother's credibility as opposed to making credibility determinations of the court's own?
I think as set out in the brief, and I think in our brief, we outlined every instance where the trial court made affirmative decisions of its own, found that the mother's testimony was the court did not credit that testimony. I don't think it was from the department's record. I think that she was her credibility was at issue when the records from Spectrum came in toward the end of the trial, and they kind of basically impeached everything that she had testified to at the trial. And on cross-examination, she testified to a number of things that in the records where she had told totally different versions of her history and of issues throughout. So I think the trial court made an independent and totally substantiated credibility determinations as to the witnesses and as to mother, which is the trial court's kind of the discretion afforded the trial court to make those decisions at trial. And so I don't think the trial court took the department's word for it or the records, but made independent decisions based on the and made credibility determinations as to that. I think that the trial court also looked at heard testimony from all the witnesses and made those independent decisions. I'm not sure if there's any other questions.
I'll check with the panel to see. Justice Milky, Justice Didcoff, I see no further questions. All right, well, thank you all three of you very, very much. The briefs were very thorough and very helpful. So we'll take the case under advisement. We'll give it our close attention. We know these cases are very difficult for everybody involved. We hope to do our best to get you an answer, as I said, very soon. And meanwhile, on behalf of the panel, we hope that all three of you stay and your families